Today's episode takes us back to Harris County Criminal Court in Houston, Texas, where Judge David Flecher is known for demanding that the state meet its burden from the very beginning. Today, we examine 3 probable cause hearings, starting with a DWI case where the evidence came under serious scrutiny. On December 28, 2024, Jerry Allen was arrested and charged with DWI, his second offense following a prior conviction in 1992. The case reached Judge Flecher for a probable cause hearing on January 3, 2025, after an alleged lane drift led to his arrest.
Sir, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Hey, senor, hat off. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On December 28, 2024, the officer came to a stop behind the defendant's vehicle, and the light turned green, and the defendant's motor vehicle proceeded, and the defendant's vehicle immediately drifted approximately halfway onto the shoulder with other motor vehicles around it before the driver jerked back into the lane. Traffic stop was then initiated, and the officer made contact with the defendant, the driver, and sole occupant of the vehicle. The officer observed slurred speech, bloodshot eyes, unsteadiness on feet, and an odor of an alcoholic beverage. The defendant admitted to consuming 1 alcoholic beverage, and standard sobriety tests were administered. HGN 6 out of 6. The walk and turn on one leg stand could not be performed due to the defendant complaining of leg pain. The defendant was read the DIC and consented to breath. The result was 0.192. However, the defendant was unable to provide a second sample and consented to a blood draw.
Mr. Allen, I'm going to find that there's probable cause to go forward with your case. Does he have a license?
It's eligible, Your Honor.
All right. How many prior DWIs does he have?
He has 1 prior, Your Honor.
1? Okay. Mr. Allen, I'm going to find that there's probable cause to go forward with your case, and I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You have a valid license. You cannot drive unless you also have valid liability insurance in your name, and I'm now placing a restriction on your license that you are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I will revoke your bond, put you in jail. Do you understand? I'm sending word and notice to DPS so that every police officer in the state is going to know if you get pulled over and you're driving a vehicle that doesn't have an interlock, they're going to arrest you on the spot. Do you understand? I see that you have a lawyer. Because you have a lawyer, I will waive your appearance, but you must stay in touch with Mr. Stewart and he will tell you when you have to come back to court. You don't have to waste your time coming back here, but you must stay in touch with counsel and he'll tell you when you have to come back. You understand?
So I need to wait for him now?
We're going to have you wait for him now, but after today, I'm going to waive your appearance so you don't have to waste your time. We'll just have you work and do your life while we get evidence, or while he gets evidence to work the case up.
Wait for him.
Right. I'm going to have you sign a reset. I'll have you meet with Flecher for bond conditions, and we'll just have you waiting back for Mr. Stewart to show. Okay? Please.
Right this way.
Ready?
Yes.
Come on up.
Good morning.
Hey, how are you? Mr. Stewart, what's new?
Sir, how was your New Year?
Great. We did PC on your case.
Okay.
We just did stand up. What's your guy's name again?
My last name is Allen, Your Honor. I would like to make an argument on PC. I don't know whether.
Absolutely. I'm always ready to hear. So refresh my memory. What happened?
So in Allen's case, it was where the officer came to a stop behind the defendant's vehicle and the light turned green. The defendant,
But he had expired registration, right?
No, Your Honor. In this case, the defendant's vehicle proceeded through the green light and immediately drifted approximately halfway onto the shoulder with other vehicles around it and then jerked back into the lane.
Were there any other vehicles around when this happened?
Yes, the officer explicitly wrote there were other vehicles around the vehicle before the driver jerked back in the lane. So he went into the shoulder and there were other vehicles.
Go ahead.
Yes, sir. My argument is, Your Honor, that, as far as what's actually alleged, says the light turned green and the truck along with several other vehicles proceeded, which obviously is in compliance with the law. The only argument that the state has made here elucidated is that they observed a Silverado drift into the shoulder with other vehicles around it. If he's drifting into the shoulder, that's not endangering any other vehicle. That's not an allegation of the safety of anybody else out there on the roadway. The shoulder is away from any other vehicles. Maybe he's doing this in an abundance of caution. There's no indication that it was dangerous or endangered any other vehicle, anything like that within the allegations here. Furthermore, there's numerous reasons why a vehicle is 100% legally allowed to drive in the right-hand shoulder of a vehicle. I think there's 9 reasons in the state of Texas why a vehicle is allowed to drive in the shoulder. There's nothing here that alleges that basically he committed any sort of crime that would lead the officer to then stop him. This is insufficient information. And I would argue that there's not valid probable cause here on this case.
I think he has a valid point where, perhaps he's, I don't want to speculate. And you're saying, well, maybe he did it because of this, but I don't want to speculate. Right. Because were there other cars? I don't know. Was it dangerous? I don't know.
Judge, but failure to maintain a single lane when there are other vehicles within the vicinity is a valid reason for a stop.
Right, but you got to articulate facts as well, right? So according to the statute.
Right, and I understand because we've had this issue before where it's failure to maintain a single lane, but we're unsure if there's other vehicles. That I can appreciate and understand. But in this case, the officer did specify that there were other vehicles in the vicinity. And under Texas law, that is sufficient for a stop.
I disagree. I think that when we look at the statute for failing to maintain a single lane, the second half of the statute is that it endangered somebody. And there's no indication here that there was any danger.
Was it 545.460? Isn't that it?
Fleming, Harden.
545.060, on Section 8.2, may not move from the lane unless that movement can be made safely. Shall drive as nearly as practical entirely within a single lane, and 2, may not move from the lane unless that movement can be made safely. There's no allegation here that the movement was made unsafely, or that there was anything unsafe.
I also have the list of, where under Texas law where it's permissible to drive on the shoulder, to stop, stand, or park, to accelerate before entering the main lane of traffic, to decelerate.
Let's do this. This is going to take quite a bit of more time. So can you come back? Do you have anywhere else to go? Let me go through the arraignments, get everybody done and out of here, and then because this is going to take quite a bit more time.
Yes, sir. Yes.
Right? And I'll give you time to take a look more, so if you need to, you too as well, if you want to try to find case law. Let me just go through, because I have another lawyer that's waiting,
Absolutely.
Yeah, I'll help you out, but let me get through everything. Yeah, for sure.
If we may, upon reviewing case law, so as we've discussed before, so he did veer into the shoulder and then go back onto the lane. And in Hardin, failing to maintain a single lane with the added vehicle component is the danger that they provided in the case law that makes failure to maintain a single lane, unlawful. Furthermore, in cases such as Lamming and Martinez, the court added additional factors to consider for the officer into determining whether or not failing to maintain a single lane is unlawful. And one of those is the time component. In Martinez, it was at midnight or at 1 o'clock in the morning. Here it was midnight as well.
No, but one of the things is there's an element of unsafetyness, right?
Yes, and Your Honor, there are other vehicles around. As the officer articulated in the dims, there are other vehicles around when he veered and then jerked back into the lane, as the officer put in the dims.
But I get it. But where are the other vehicles? Are they next to him? Are they in front? Are they in back? He doesn't articulate it. All he says is there are other vehicles.
And furthermore, Your Honor, what he did articulate into the shoulder, and upon looking at the statute for that, the Court of Appeals in Lothrop v. State articulated that there are 7 permissible reasons to go onto the shoulder. And there is reasonable suspicion to perform a traffic stop where there is not one of those permissible reasons. And here, the officer did not, with those other vehicles saying he passed the green light and then go halfway into the shoulder and then jerk back, it implies that there is not one of those 7 reasons to allow another car to pass, to stop or park, or to accelerate before entering the main lane of traffic, or decelerate before making a right turn. None of those are present. None of the 7 reasons articulated in the statute on the Transportation Code 545.058 are present. So that alone, him going into the shoulder without a permissible reason, is enough to perform the traffic stop. And that, taking that into account with Hardin, which he veered out of, he failed to maintain a single lane with other vehicles around, provided enough of a community danger to allow the officer to perform that initial stop.
Man,
where's the danger?
It would be the other vehicles present, Your Honor.
He doesn't articulate that, though.
He does articulate that there are other vehicles.
All he says is there are other
And
vehicles.
Judge, that is all the case law requires. He doesn't have to say there's a vehicle right in front and right next to him. The case law requires that there be other vehicles within the vicinity for it to be.
Right. In the case law,
You don't know if it's in the vicinity, though. All he says is that there are other vehicles. That's so vague. You say other vehicles in the vicinity. He doesn't say that they're in the vicinity. He just says there are other vehicles, and that's so vague and conclusory.
Your Honor, the case law does specify there only needs to be a minimal level of justification for the stop. In this case, that is enough where there's other vehicles around to provide that additional threshold for failing to make a single lane. In addition to no permissible reason to enter the shoulder, there's nothing there to indicate
Right.
there is a permissible reason.
If we're taking outside of the failure to maintain a single lane, and we can go into the other part of the transportation code that this defendant violated, which is veering onto the shoulder, he did not do so for one of the 7 permissible reasons, and thus the officer has reasonable suspicion to stop it.
You're veering. That is 545.060, right? Isn't that part of that's the weaving, right?
It's a different one.
Because you just said there's another violation of the transportation code.
Yeah, and it's under 545.058 is for entering the shoulder.
May I address the court, please, Your Honor?
Hold on, let me pull that code up. So that's 545.
.058.
The transportation code.
All right, let's see. That is driving on an improved shoulder. An operator may drive on an improved shoulder to the right of the main traveled portion of a roadway if that operation is necessary and may be done safely, but only if to stop, stand, or park, to accelerate before entering a main travel lane of traffic, to decelerate before making a right turn. Okay.
Yes, Your Honor. So in terms of their arguments about the driving on the shoulder under Lothrop, their case that they're citing, the case itself says, and I quote, merely driving on an improved shoulder is not prima facie evidence of an offense. That's their case. It says the exact, that doesn't benefit them at all. In terms of Hardin, their own case, based on our review of the record and precedent, we conclude that the detaining officer did not have reasonable suspicion to stop Applee for violating Transportation Code Section 545.060. Again, that's their case. And in that one, that's where the vehicle's tires crossed over the fog line, just as in our case, into the shoulder. And in their own case, it says that was not reasonable suspicion. And so, I would like to, highlight these two cases because I think they're directly on point. I don't know why the state did. In terms of State v. Hernandez, which is 2016 out of the 4th Court of Appeals, and I have the appellate case number, but I don't have the specific site.
My only concern is there an element of unsafetyness? That's all I want to know.
To just address one point briefly, in the case Lothrop, they do say that really on an improved shoulder is not prima facie case evidence of an offense. However, if it states explicitly that the offense of illegally driving on an improved shoulder can be proven in one of 2 ways, either driving on an improved shoulder was not necessary part of achieving one of the 7 approved purposes which are articulated in the statute, or that it could not have been done safely. And here, we're again going back to the 7 articulated purposes in the statute that are not present here. He entered halfway into the shoulder and then jerked back into the lane. After previously having just gone through a green light. So there's no indication that he's allowing a vehicle to pass or anything like that. He went through a green light, entered the shoulder, and then jerked back.
So by your theory, then, any single person that ever drives a mere nanosecond to the right of an improved shoulder is now violating this offense, this transportation code.
He wasn't
The
just
law can't be like that.
It wasn't just announced. He went halfway in. So he veered halfway into the shoulder. It wasn't just like a little deviation. He said, the officer said halfway into the shoulder and then jerked back into the lane. So he went out and then came back into the lane.
So are we supposing that that's like half a second of driving on an improved shoulder? Is it 1 second? Is it a minute? Is it?
I'm sure it should matter. I mean,
because the legislature articulated 7 specific reasons why that would be permissible, and they wouldn't have.
If an old grandmother who is 70 years old is driving on a freeway and accidentally
And that's, but that would provide the minimal justification just to perform an investigative, a stop, just to investigate. It wouldn't be an arrest or anything like that. It would just be the traffic stop would be allowed at that point.
I don't know. I don't think that the officer wrote enough in the report. I don't think that the unsafetyness as far as, saying that there are other cars around, I just don't think that there's enough.
Yes,
All right.
Judge.
I'll find no probable cause.
Thank you.
Okay.
Although Judge Flecher initially found probable cause, defense attorney Craig Stewart challenged the legality of the traffic stop, prompting the judge to reconsider. The stop was based on Mr. Allen's vehicle briefly drifting halfway onto the improved shoulder before returning to its lane. The state relied on 2 Texas Transportation Code provisions concerning lane movement and driving on the shoulder, but Judge Flecher found the officer's report too vague to establish either violation. The report mentioned other vehicles nearby, but failed to explain their location or show that Allen's movement was unsafe. It also did not rule out a legally permitted reason for using the shoulder. With no lawful basis for the traffic stop, the judge concluded that the evidence supporting the DWI charge could not stand. Since the intoxication evidence came directly from the stop, Judge Flecher found no probable cause, and the case was later dismissed on February 24, 2025. Our next case involves Michael Hardy, who was charged with possessing less than 2 ounces of marijuana. He appeared before Judge Flecher for a probable cause hearing on December 31st, 2024.
Why on 2 different sides? You embarrassed to be with your mom? Okay.
I separate
Got it.
family and spectators.
Okay. Good morning, Mr. Hardy.
How you doing?
Mr. Hardy, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. Shh. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge.
Okay.
On November 22nd, 2024, the officer observed the defendant's vehicle parked more than 18 inches from a curb on a public roadway in the right lane of a two-way road in Harris County, Texas. While the officer ran the motor vehicle, the passenger side door opened, a black female exited, and the female approached the patrol vehicle. The officer made contact with the female and observed a strong odor of marijuana emanating from the female. The officer made contact with the defendant, the driver of the vehicle, and observed a strong odor of marijuana and had the defendant exit the motor vehicle. A PC search was conducted and the officer located 3.5 in the driver's side door and 1 blue package with Oops All Berry on the front containing green leafy substance on the rear driver's side floorboard, 1 red package with Fruity Pebbles on the front containing a green leafy substance in the back seat, and 2 clear plastic baggies containing green leafy substance under the front right passenger seat. The officer also observed 1 burnt marijuana cigar behind the front passenger seat and 1 small chunk of loose green leafy substance in between the driver's seat and the door. The green leafy substance was identified as marijuana based on training experience, and the weight was 54 grams or 1.9 ounces.
He was doing what that was wrong?
So he was parked more than 18 inches from the curb on the right lane of a two-way road. So he was out.
On earth are you going to know that you're parking more than 18 inches? What time of day or night was this?
Your Honor.
Is it parking while black now? Come on.
Yeah.
Your Honor, there's no time listed. It just says the officer was on patrol around the 3518 block of Arbor Glen Drive when he observed the vehicle parked more than 18 inches from the curb.
And so he goes up to the car because of that?
No, Your Honor, a female passenger side exited the passenger side and approached their vehicle, and he observed a marijuana.
Oh, but because he comes up to them. Right? Stop. Are you losing?
The officer wrote as he ran the vehicle, presumably the license plate.
Right, he pulls him over.
They were already parked on the side of the road 18 inches from the curb, and he came, I guess, parked behind, and he was running the vehicle, and then the passenger side door opened, a black female exited and approached his vehicle, the patrol vehicle, and he observed an odor of marijuana on the female, and then he made contact with the driver, where he observed marijuana odor in the vehicle. So the female approached the patrol vehicle.
Show me in the penal code that code. What is the penal code for that?
Regarding the 18 inches from the curb, sir, is that the issue of what we're talking about?
Yeah, because they come to him because he comes to them, right? They're just parked. He comes to them.
It's got to be a transportation code, not penal code, you know?
And Your Honor, regarding the timeline of events, it does appear that when they were parked that distance away, which could be arguably further, I don't know what it looked like at that time, but the female passenger is the one who exited first, and that was before officers ever made contact with them. So I don't know if you were thinking that the officers approached them first, but I just wanted to clarify that she approached first.
What time of day or night was this?
Trying to see that, Your Honor, in a second. It's at 4 in the morning,
And Your Honor,
4 in the morning.
4:30 a.m.
And you can delineate at 4 in the morning that parking 18 inches from a curb.
And I found the regulation, the statute in the transportation code where it says you have to park within 18 inches.
At 4 in the morning, you can tell.
Your Honor, the officer was,
Yeah,
yes.
I don't think so. All right, I'm going to find no probable cause.
Yes,
All
Judge.
Guys, be careful, right? You know, they're always out there. Just be careful. Do something with your life. Knowledge is power. Get into school, get an education.
Judge Flecher questioned how an officer could determine at around 4 in the morning that Mr. Hardy's vehicle was parked more than 18 inches from the curb. Under Texas Transportation Code Section 545.303, vehicles parked on a two-way roadway must have their right-hand wheels parallel to and within 18 inches of the curb or roadway edge. But once the prosecutor confirmed that the encounter happened around 4 to 4:30 a.m., Judge Flecher questioned whether the officer could reliably make that determination in the darkness. Because the alleged parking violation was the only stated reason for the investigation, the judge found there was no legal basis to detain Mr. Hardy. As a result, the evidence obtained during the investigation could not support the case. Judge Flecher found no probable cause, and the case was dismissed on January 7th, 2025. Our final case involves David Clear, who was charged with DWI with an alcohol concentration of 0.15 or more. His probable cause hearing took place before Judge Flecher on March 24th, 2025.
Morning, sir. Sir, you were charged with driving while intoxicated. First offense, it's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 17th, 2025, an officer was dispatched to a call for service at the 400th block of West Gray Street, Houston, Harris County, Texas. Upon arrival, the officer observed the defendant sitting inside his vehicle. The officer made contact with the defendant and observed the defendant to have bloodshot eyes, unsteady balance, and was confused. The defendant stated he didn't have anything to drink. A Houston Fire Department employee, the wheel witness, stated the defendant was asleep in the driver's side of the vehicle with his foot on the brake and the vehicle in drive. The wheel witness stated he had a hard time waking up the defendant. SFSTs were conducted. 6 out of 6 clues were observed on the HGN, 5 out of 8 clues observed on the walk-in turn, 3 out of 4 clues observed on the one-leg stand. The DIC was read and the defendant consented to a breath test. The results were 0.179 and 0.175.
Where was he? Was he in the middle of the road?
It sounds like,
He...
yeah, I don't. So it says that he was sitting inside his vehicle on the 400th block of West Gray Street, which is accessible to the public. On a public road.
Don't, please. I have no idea what that is, where it is. Is he in the middle of the road? Is he in a parking lot? Is it Domino's Pizza? I mean,
It says it's on a public street. It says, well, more specifically, it says 400
My
block of West
goodness.
Gray Street is a public street.
I mean, I need more information. I mean, does it say he's on the street there, or are you assuming?
No, I'm not assuming. I'm saying what it says is that the 400th block of West Gray Street is a public street. It doesn't say specifically.
Doesn't ask him if he's driving, none of that. I mean, really.
Yeah, he did have the vehicle in drive with his foot on the brake and was unconscious. But in regards to the location aspect of it, there's nothing further stated on that.
I'm sorry. I'm going to find no probable cause. I can't just go forward with assumptions here, you know? Mr. Cleary, be safe, man. You know, we have every single day. Look, this weekend, how many people died on the road here in Harris County? You know, really,
Be smart.
Thank you.
You know, you have but one life. Don't do something where you either ruin your life or, more importantly, ruin someone else's life. Okay?
I appreciate
Please
that.
take a seat for me, sir. I'm going to find no probable cause.
Judge Flecher found no probable cause in David Clear's DWI case after the state failed to establish exactly where his vehicle was located and whether it was actually in a public place. Under Texas law, DWI requires a person to be intoxicated while operating a vehicle in a public place. The officer's report stated that Clear was found in his vehicle while responding to a call on the 400 block of West Gray Street, but it never explained where the vehicle itself was located. When Judge Flecher pressed the prosecutor for that crucial detail, the state could only point to the fact that the block was a public street. The judge refused to fill the missing information with assumptions and concluded there was not enough evidence to establish probable cause. The case was dismissed on March 31st, 2025. These 3 hearings demonstrate why probable cause matters. In every case, the state's report provided conclusions without the specific facts needed to support them. Judge Flecher refused to assume that other vehicles made a lane change unsafe, that an officer could accurately judge an 18-inch parking distance in darkness, or that a vehicle was actually in a public place. The burden remains with the state to justify both the criminal charge and the police conduct that produced the evidence. By carefully examining the facts at the earliest stage, a judge can prevent unsupported cases from moving forward and protect defendants from unnecessary court proceedings and legal pressure. Thanks for watching. If there's a courtroom case you'd like us to explore, let us know in the comments, and don't forget to like and subscribe.